Welcome everyone to our webinar today. This is part 4 of our Trump administration series, and today's topic is the immigration consequences of criminal activity. My name is Avi Friedman. I'm a partner and an attorney at Wolfstorff Rosenthal. We are an immigration law firm. I am based in our main office in Santa Monica, California in the Los Angeles area, and we also have another office in New York City. As you can see, our contact information is on the screen. You have our website, my email, and our phone numbers. Some basic information about our office is listed on this slide, and as well as information about myself and my credentials. What we're going to be talking about today is basically covering an overview about the consequences and the impact of criminal acts with U.S. immigration. And we'll be covering some common criminal offenses. We'll be talking about crimes of moral turpitude and talking about the impact in terms of admissibility and removability and where it comes into play. So for instance, at the U.S. visa process, at a U.S. embassy or consulate, as well as at the admission process with Customs and Border Protection. So let's start off with an overview about some common criminal offenses. And you can see on this slide, for instance, domestic violence, DUI, battery assault, sexual offenses, theft, shoplifting, and even arrests for unpaid traffic tickets when those go out for warrants. I wanted to go through the basics of the concept of inadmissibility. And foreign nationals are inadmissible to the United States when they have characteristics or have engaged in conduct for which our U.S. Congress has deemed undesirable and created laws or regulations preventing those folks from being issued visas, being admitted to the United States, or after leaving without a waiver of inadmissibility, not being able to come back to the United States. These are covered in the Immigration and Nationality Act in Section 212A for classes of inadmissible aliens. Now, there's also this concept of removability. And so somebody is in the United States and they become removable from the United States if after they enter the U.S., they exhibit these additional characteristics or engage in the behavior for which Congress has prescribed. Removal grounds tend to be quite narrower than grounds of inadmissibility. The concept is that it should be harder to remove a person who is already in the United States and has established roots than somebody who is outside the United States and is trying to get into the U.S. And you can find the removal grounds at the Immigration and Nationality Act, Section 237A. So for an overview of common criminal activity that can have immigration consequences, we're going to go through these next couple of slides. And basically, if you admit to or you're convicted of a crime or crimes involving moral turpitude, CIMT, if you've been convicted of 2 or more crimes with an aggregate sentence of 5 years or more, a conviction of a domestically related crime, a conviction of an aggravated felony, admission of or conviction of drug-related offenses, drug-related activities that don't result in a conviction, so drug trafficking or drug use, alcohol abuse, security-related offenses, whether or not they result in a conviction, espionage, sabotage, terrorist activity, prostitution activities, and certain firearm offenses. These are all common crimes that can have very serious immigration repercussions. Now, these are some domestic offenses that have very serious and negative immigration consequences: spousal abuse, child abuse, stalking, violating a protective order, simple battery, and even though some of these offenses will be misdemeanors with very minimal jail time or sentencing, they do have very serious immigration consequences and can result in removal, and oftentimes there will be very little or no relief available to fight it from an immigration context. For an example of crimes involving moral turpitude, you could see here aggravated assault, spousal abuse, arson, forgery, child abuse, embezzlement, robbery, burglary, theft offenses, counterfeiting, and fraud offenses. These are examples of what a crime of moral turpitude is. Some examples of crimes that do not involve moral turpitude would be a simple assault, a simple driving under the influence, disorderly conduct, most traffic violations, trespassing. Now, let's talk about the concept of an arrest. What is an arrest? Well, an arrest occurs when someone is ordered to accompany a police officer against their will, whether or not they are restrained. Once there's an arrest, it has to be admitted to in all U.S. immigration contexts and on all applications whenever the question is asked, have you ever been arrested? It doesn't matter if the arrest or conviction has been expunged. It's not relevant from a U.S. immigration perspective. So even if the case is sealed, that still will have to be admitted to in a U.S. immigration context. Now, once somebody is arrested, generally the fingerprints are taken by the police agency and it gets forwarded on to the FBI. And the FBI shares this information regarding arrest through the National Crime Information Center, the NCIC. And so when somebody goes in and applies for a visa, the consular officer runs an NCIC check. When somebody's applying for a benefit stateside, let's say an adjustment of status, biometrics are done, and that's run against the NCIC database. Once you have a hit for an arrest, there can be delays for visa issuance. You could encounter a problem with Customs and Border Protection at a U.S. port of entry, and also while pending an immigration benefit with U.S. Citizenship and Immigration Services, there may be delays while they investigate the arrest and the outcome. Now, even if there's no conviction, just having an arrest on your record can have immigration consequences, and we'll go through some details on some of these in a little bit. But for instance, driving under the influence, drug use or possession, drug trafficking, even if there is no conviction, prostitution, terrorism, espionage, or sabotage charges. All of these can have serious immigration consequences just by virtue of the nature of the arrest. Possible consequences of criminal activity include being inadmissible, being removable, or being subject to court proceedings, deportability, can lead to potential violation of your immigrant or non-immigrant status if it leads to you being removable as a result. And that can result in ineligibility for U.S. visas, adjusting your status in the United States, or other immigration benefits. So what is a conviction? Well, under U.S. immigration law, conviction is defined as a formal judgment of guilt of the alien entered by a court, or if adjudication of guilt has been withheld, where a judge or jury has found the alien guilty, or the alien has entered a plea of guilty or nolo contendere or no contest, or has admitted sufficient facts to warrant a finding of guilt. And then the next prong is the judge has ordered some form of punishment, penalty, or restraint on the person's liberty to be imposed. So again, I go back to that concept of expungements of the conviction or the arrest, and most pardons, they don't have an effect on a conviction in the immigration context once there is a formal conviction on record or there's an admission. So following through on what is convicted, a lot of times somebody may not understand that they have been convicted. A lot of times some states have programs called diversion, and it may require a guilty plea, or sometimes they allow a non-guilty plea, and once the diversion program is completed, the charges may be dropped. But if the person pled guilty and had a sentence, that will still count for U.S. immigration. They may have received a fine with no jail time, or they received a formal expungement. And even though that will still count as a conviction. A conviction for some misdemeanors, as we talked about in the beginning, can have very serious and negative consequences when someone is applying for a U.S. visa or trying to re-enter the United States if they have a valid visa or valid green card. So once there's a conviction, what happens next? Well, if it's not so serious, then Immigrations and Customs Enforcement doesn't really look at it and doesn't pick up on it. If it's a serious crime, there might be an ICE hold, and the person might also be placed in ICE custody. Even though a conviction might not be serious enough to cause immigration consequences, it still must be admitted to in all immigration contexts. And what we're starting to see, and today is an important day, there's bound to be some, either today or tomorrow, some new executive orders on immigration from President Trump, and it's very likely that folks that have criminal convictions and are going to be in the spotlight. We've yet to see the formal executive order, but do stay tuned, because it's very likely that this is going to be even more of an issue very, very soon. So how is criminal activity detected by the government? As we talked about, that NCIC database, consular posts use it to obtain the U.S. criminal record. So they get the arrest report. They can see the court disposition, whatever's listed by FBI. Consular officers also look through CLASS, which is the Consular Lookout and Support System, computerized search system where they verify somebody's name and see what's showing up under that. And also, they find out by the person's own admission on application forms, whether it's for a U.S. visa, admission, or for benefits. Generally, there's a question: have you ever been arrested? Have you ever been convicted? And so on application forms, the person under oath is answering the question, and oftentimes at visa interviews or green card interviews, citizenship interviews, these questions are asked. Very recently, the Department of State, and what you're seeing here is a cite to the Foreign Affairs Manual, or FAM for short, provided an update regarding revocations of non-immigrant visas. And a revocation of a visa will occur if a consular officer determines that the alien is not eligible anymore for that particular visa classification, if the alien has been issued an immigrant visa, if the visa has been physically removed from the passport, or the alien is subject to a watch list promote hit for an arrest or conviction of driving under the influence, driving while intoxicated, or similar types of arrests and or convictions, DUIs, that occurred in the last 5 years. So the process is such that the person is notified of the Department of State's intention to revoke the visa. The alien is supposed to have an opportunity to rebut why the visa should not be revoked, and the consul will then request the person to submit the travel document or passport in which the visa was issued and they want to revoke. Now, under Immigration Act 212A, consular officers generally can only revoke a visa if the alien is ineligible or is no longer entitled to that classification. But there's also a concept called Prudential Revocation. And Department of State can revoke a visa when it receives derogatory information from another U.S. government agency. So it could be an intelligence or law enforcement community. Generally, with the exception of DUI offenses, a consular officer cannot revoke a visa when the person is physically present in the United States. And why the exception for DUIs? Well, DUIs is an indicator of a possible other ground of ineligibility for physical or mental disorder with associated harmful behavior. So it's to Department of State, it's a very serious offense, even if just arrested. So let's go into some details about prudential revocations for DUIs. And again, you have the cite to the Foreign Affairs Manual. So consular officers now have the authority, without even referring back to the Department of State Visa Office in Washington, to prudentially revoke a visa on the basis of this INA grounds when there's a watch list promote hit. And this is for an arrest and or conviction of DUI. You don't need a conviction. All that triggers it is an arrest. So even if later on the case gets dropped completely, or it gets or there's a conviction for something non-alcohol related, all it takes is an arrest for a DUI to trigger the possibility of a revocation of the visa. Now, it will not happen if the arrest has already been addressed in the context of a prior visa application, or if it's a different type of alcohol-related arrest, such as public intoxication, that does not involve operation of a motor vehicle. For individuals in the United States, revocations based on the DUI arrest are effective upon their departure from the United States. So the revocation doesn't happen while you're in the United States. The second you leave the U.S., the revocation takes effect. Now, for those arrested for a DUI offense, and again, we're talking about non-immigrant context, whether or not you're ultimately convicted, the consular posts that issued the visa will get notified, and they will cancel it. And they contact the person generally by the information provided on the DS-160. That's the online visa application form. They may call them, they may send an email, and sometimes they even send letters via mail. Now, ICE may be notified, but generally Department of State does not recommend action. They just notify the other government agencies. If the person departs the United States, they're going to be ineligible to return to the U.S. until they go through the panel physician process, and a doctor will have to clear them and find that they do not have a problem with alcohol that leads to harmful behavior, whether to property and or persons. And the issue is if there's an active case with just an arrest and the person travels with a revoked visa, a lot of times consular officers will not issue a visa to somebody when there's no formal disposition of the pending criminal case. And what happens now is that the person can't get back to the United States to attend their hearing, and they need to be there, and now a warrant gets issued for failure to appear to court. So it's a really tough predicament to be in, and the key is not to leave the United States if you don't need to during this time frame. Now, what is the effect on somebody's status with a visa revocation? And you'll see here a link to a Department of State memo. It's regarding J visas, but it's basically applicable to all non-immigrants. And it's saying that revocation doesn't mean that one's status gets terminated. Revocation is to the actual visa itself. To terminate somebody's status in the United States, they need to be put into court proceedings, or there needs to be a formal finding by the Immigration Service. So the revocation of the visa in and of itself should not affect your status. And remember, the revocation takes effect once you depart from the United States. So what can affect your status? Well, we had seen instances last year of USCIS, the Immigration Service, denying some benefits due to Department of State revoking non-immigrant visas. For instance, OPT, optional practical training applications, were denied. We think that was a fluke, and that Immigration Service says that has been fixed. Both USCIS and the Department of State have confirmed that revocation should not impact non-immigrant status or eligibility for some student benefits. But if you look carefully at the immigration rules and laws, it does say that an alien who's present in the U.S. in violation of the Act, or whose non-immigrant visa or other documents has been revoked, is deportable. So there is some issues in terms of the way the immigration laws read. So what happens at a consular post when there's alcohol or drugs involved? Well, the key is that if there's an arrest and or conviction in the last 5 years for a single DUI, or two in the past 10 years for alcohol or drug-related offenses, or exhibits of other evidence of abuse, the person is referred to a panel physician. The doctor assesses whether the person has an alcoholism or drug abuse problem, and if so, the doctor can make a finding of a Class A health condition. If so, the person has to remain outside the United States for at least 1 year and be able to prove to the panel physician that they are clean, that they have abstained from drugs or alcohol. The panel physicians are appointed and controlled by stateside, and basically they are contracted by the local U.S. embassies and consulates. So you can't just go to any doctor These are doctors that are sanctioned and under contract with the Department of State and the U.S. Embassy and consulates. And now, even if the medical exam is clean, if the applicant admits to illegal drug use even once, again, they're going to be required to remain abroad for 1 year and show that they have been clean before they're going to be eligible for a new visa, whether non-immigrant or immigrant. Also, if the consular officer has a reason to believe that the person is an abuser, they can refer them to the panel physician for a medical exam, including drug test, alcohol test, to make sure there's no evidence of use or abuse. Also, if there's any involvement with drug dealing, there may be a reason to believe on the part of the consular officer. So where else does the issue of criminal conduct arise? Well, at the U.S. port of entry, we have Customs and Border Protection officers, and they also review admissibility, and criminal issues do come up in their system. So when you're coming in at the port of entry and they're scanning your passport and your visa, they're also running your information, your fingerprints, your names, doing their own checks through the various governmental databases. Now, Customs and Border Protection generally should not refuse admission to somebody unless they are inadmissible. This would be a drug conviction, a felony DUI. We have heard reports of CBP officers canceling visas for DUIs or arrests and or convictions. Now, if you do have an arrest on your record and a conviction, it's likely going to result in being referred to secondary inspection at a port of entry. So you're coming in at the airport, you meet with the first officer at the booth, the arrest shows up. Even if the case was ultimately dropped, it's very likely you'll be sent to secondary inspection, and you could be sitting for a few hours while they review what occurred. And it's often helpful to have a legal brief to accompany with you if you've ever had an arrest on your record, to explain why that should not impact from a U.S. immigration point of view. Now, they could admit you and allow you to get into the United States and ask you to appear at a CBP office for a deferred inspection hearing. And this is a meeting with a CBP officer where they're going to go through your records very thoroughly before they decide whether they will formally admit you into the United States. Now, at the port of entries at the airports, attorneys are not allowed to represent applicants. At the land port of entries, it's discretionary. Attorneys may be allowed into the waiting area. Some CBP officers do allow attorneys to come up to the window, but the level of representation is at the discretion of the CBP officer. At deferred inspection meetings, attorneys can accompany and participate in the process. So again, if you do have a deferred inspection appointment, if you do have a criminal issue on your record and you're traveling and re-entering, it's always good to have a packet prepared by an immigration attorney analyzing and advising why you are admissible. Now, the CBP officer at the port of entry can ask questions about the incident, and when they see one thing, it often leads to a fishing expedition, try to explore other areas. Remember, CBP can search both your bags and your electronic devices. They can access cell phones, laptops, so none of that can be withheld from them, and they can and they will search through those electronic devices. If serious enough, they can take you into custody. You would be treated as an arriving alien, which means you have fewer rights, and you may not have a right to a bond hearing. So again, I repeat, the issue is that it's always good to travel with copies of the arrest report if you have an arrest, certified copies of the court disposition, and an attorney brief that thoroughly analyzes and shows why this should not render you inadmissible. And if you are in doubt, I do recommend you consult with Immigration Counsel, have them review all these documents and provide you with an opinion on whether it's even safe to travel and whether you have admissibility or removability issues. So what about the issue of recreational and medical marijuana use. What we're seeing now is more and more states authorizing the use or possession of marijuana, even if used for medicinal purposes. But the key is that marijuana still remains an offense under the federal law. So here, you don't even need a conviction. If you're found to have used it or possessed it, that can qualify under federal law. So even though the states may authorize it, it's still an offense under federal law and can render you inadmissible or removable. There is a limited waiver for single offense of simple possession of 30 grams or less. For certain instances, very limited. There can also be a finding that you're a drug abuser or addict. Remember, we talked about this. CBP can search your person, your baggage, your cell phones, and I have seen instances where somebody had images of marijuana or other drug paraphernalia on their phone, and that led to further lines of questioning and issues with Customs and Border Protection. So before you're really eligible to use it in accordance with state laws, the key is you have to become a U.S. citizen first. Being here in non-immigrant context or on a permanent residence and using or possessing marijuana still is an offense under federal law and under U.S. immigration. Now, there is a waiver possible, and this is in the non-immigrant context, for applicants who have overcome the general 214B concept and have another ground of inadmissibility. The way that this non-immigrant waiver works is that at the visa interview, if you qualify for the visa, you request this waiver from the consular officer. And the consular officer will make a determination, and they're weighing key factors. They're looking at how serious was the offense, how recent did it occur, and what evidence is there of rehabilitation. And generally these factors are weighed. It's a balancing test, and if the consular officer feels a waiver is advisable, they make a recommendation. And it's not the approval, but they recommend the waiver, and now the waiver gets sent out to Customs and Border Protection, the Admissibility Review Office, or ARO, and they will be the final arbiter in terms of whether to approve or deny the waiver. The waiver process takes, on average, about 6 to 8 months. It's not a fast process. It used to be only a month or two. Now it does take significantly a long period of time to be adjudicated. If the waiver is approved by ARO, the visa then can be issued, and the waiver can be valid for up to 5 years. But if the consular officer does not recommend the waiver, then the file doesn't move forward, and it never gets into ARO's hands. They won't see it. So in that circumstance, one can ask a consular officer to seek an advisory opinion from the visa office in Washington, D.C. The visa office, on their own accord, can recommend a waiver, but very rarely do they overturn the judgment of the consular officer who's on the line and doing those frontline visa interviews. Now, when you see the waivers, and if the waiver is ultimately approved, then the consular officer gets notified. They can issue the visa. On the bottom of the visa, there will be an annotation about the D3 waiver. And when the person comes in at the port of entry, they're still likely, even with the waiver, to be subjected to secondary screening with Customs and Border Protection, sent to secondary, and CBP will still go through the details about why they're inadmissible and verify the criminal record. Now, if you do have a criminal incident, an arrest and or a conviction, and that does not render you inadmissible, and you're undergoing issues with Customs and Border Protection fairly frequently, you can also consider doing the DHS TRIP. That's the redress program, where you can ask them to review your file, and they may or may not clear that up depending on how serious the criminal incident is. So I wanted to thank everyone for joining us today for our webinar. You have my email contact information. It's afriedman@woolsdorf.com. If you have follow-up questions, you're more than welcome to send an email and we can review it. I do recommend that you review our website at wolfstorff.com. We have a lot of good information. You could sign up to receive our newsletters that are sent out on a weekly basis, and we do send out breaking news as things do develop in the world of U.S. immigration. And as I mentioned, most likely today or tomorrow there's going to be some very breaking news coming from President Trump, and sure enough, we're anticipating that there's going to be a lot of priority on enforcement side issues and going after criminal aliens, and we are likely to see an uptick in people put into court removal proceedings. So again, thank you everyone for joining us, and we hope that you'll be able to join us in the future again for one of our future webinars. Thank you.